Canadian immigration, sponsoring your spouse, partner, or dependent child. The purpose of this video is to explain the basics of sponsoring a family member to become a permanent resident in Canada. We will be focusing on sponsoring spouses and dependent children. This video is by Parkdale Community Legal Services. We have been offering free legal assistance for low-income residents in the Parkdale area since 1971. This video is for information only. If you need legal advice, please visit your nearest community legal clinic. In this video, we will cover who is eligible to sponsor a spouse or child, which family members can be sponsored, proving the relationship, and factors that may make your family member inadmissible to Canada. We will also be discussing costs, processing times, and what happens if your sponsorship application is refused. In order to sponsor a family member, you have to meet a few requirements. First, you have to be a Canadian citizen or permanent resident, and you must be 18 years or older. Second, you cannot be in receipt of social assistance other than ODSP. Finally, you will also need to sign an undertaking. The undertaking is a promise to provide for your family members' basic needs, including paying for any social assistance that they receive. You may not be able to sponsor a family member if you were previously sponsored as a spouse and became a permanent resident less than 5 years ago. Or if you signed an undertaking for a previous spouse and has not been 3 years since they became a permanent resident. Or if you previously sponsored someone and did not pay back any social assistance that they received while the undertaking was in place. Or finally, if you have been convicted of a criminal code offense, are in detention, or under a removal order. If you are eligible to sponsor, you can sponsor a spouse, common law, or conjugal partner, a dependent child, or you can also sponsor a family member of a sponsored person, such as a child or a spouse of a sponsored person. What is the difference between a spouse, common law partner, and a conjugal partner? A spouse is someone who is married according to the law of the country where they were married. The marriage must also be valid under Canadian law. A common law partner is someone who has lived with you for 12 straight months in a relationship that is like a marriage. A conjugal partner is someone you had a marriage-like relationship with for at least a year but are not able to live together due to exceptional circumstances. If you are sponsoring a child, they must also meet some requirements. To be considered a dependent child, they have to be your biological child or legally adopted, under 19, and they must be unmarried. If they are over 19, they must have been financially dependent on a parent since the age of 19 because of a physical or mental condition. Please note that the Government of Canada is proposing to raise the age from under 19 to under 22. If approved, the regulation will likely come into force in fall 2017. Who else can be sponsored? Even if you are trying to sponsor a family member who is not a spouse, a child, or a parent or grandchild, you may still be able to sponsor them in exceptional situations. For more information, seek legal advice. Once you've determined that you can sponsor a family member, you need to collect evidence to prove the relationship. If you are living together, you must provide at least 2 of the following: a joint ownership or lease of a home, joint responsibilities of utilities, or government-issued ID showing the same address. If you are not living together, you must provide letters, printed texts, emails, or chats between you and your partner. Or proof of visitation, such as plane tickets, boarding passes, and passport pages. To prove that your marriage is genuine, you can also submit the following: a marriage certificate, evidence of financial support between you and your spouse, or other documents, such as pictures, letters, tax returns, or proof of communication. Proving your relationship with your child also requires certain documents, such as birth certificates, school records listing parents' names, photos and sworn statements, or other official documents, like baptismal records, school records, hospital registries, or old passports. You and your child may also be asked to undergo DNA testing or asked to attend an interview. Even if you prove your spouse or child is a family member, they may be refused sponsorship based on their medical or criminal backgrounds. All family members have to take medical examinations overseas, must also undergo security checks. A family member may be refused sponsorship for medical reasons if they have a condition that is likely to be a danger to public health or safety, or might reasonably be expected to cause excessive demand on health or social services. Excessive demand does not apply to spouse, common law partner, or dependent children of a sponsor. An application may also be refused on the grounds of security, human rights violations, serious criminality, or organized criminality. An application may also be refused on the grounds of misrepresentation, if immigration determines that you have been dishonest in your application. The total cost to sponsor your spouse or partner is $1,040. This includes the sponsorship fee, processing fee, and the right of permanent residence fee. When you apply to sponsor a spouse, you can opt to pay the right of permanent residence fee at a later date. However, Immigration Canada recommends that you pay this fee upfront. The cost of sponsoring a dependent child is $150 per child. As mentioned earlier, when you apply as a sponsor, you also have to sign an undertaking swearing that you can provide for your sponsor family member. For spouses, you undertake to provide for them for 3 years. For children, it is for 10 years or until they reach the age of 25. The undertaking means that you will pay back any social assistance that they receive during that time. Most spousal sponsorship applications, whether in Canada or overseas, are processed within 12 months. This is one of the changes the IRCC made on December 7, 2016. Here is a breakdown of some of the changes made to the sponsorship process in December 2016. You can also find this graph on the IRCC website. If your sponsorship application is turned down, you can get a lawyer who can take your case to the Immigration Appeal Division to argue against the refusal. You have 30 days from the time you receive the negative decision to appeal. Please note that you cannot appeal if the IRCC refuses the application because your family member is inadmissible due to medical or criminal reasons. If you have an issue with family sponsorship and you are a low-income resident of Ontario, you can check the Ontario Legal Aid website to find a community clinic near you. If you are a low-income resident of the Parkdale area, you can come into our legal clinic for an intake. We are open for intake on Mondays between 2 to 6 p.m., Thursdays between 2 to 6 p.m., and Fridays between 10 to 1 p.m. and 2 to 5 p.m. If you need an interpreter, you can request one at the front desk before your intake. You can find more information on family sponsorship in multiple languages at Community Legal Education Ontario website. You can also visit the website for Immigration, Refugees and Citizenship Canada for application guides and forms.